Alex here with a legal nuts and bolts video on collateral attacks. And this is going to be a replacement video. And of course, I'm going to draw mostly on my child custody experiences. So even though it's not a high conflict child custody video, it's still a must watch for the high conflict child custody audience. What I mean by collateral attacks is trying to win your case, not necessarily by focusing on your opponent, which in a custody case would be your ex, but by targeting the judge, targeting the lawyers, whether it's your own or your ex's or your opponents, using mechanisms outside the legal process. So we've got bar complaints with the state bar, fee disputes with the state bar, the police, calling the police, filing police reports, calling CPS, that counts too. I'll explain why when I get to the video. Um, and then I guess I will go ahead and talk a little bit about forcing your attorney to do things they don't want to do. That kind of goes into this, but not as much. It's important enough that I do want to at least mention in this video. So the replaced videos, just so people know, and I'll put the links down in the description below. The 6 videos that I'm replacing are filing reports, bar complaints and fee disputes, targeting the judge, targeting the lawyer, judicial ethics complaints, and forcing your attorney. Those are the 6 videos. This is going to be kind of a bad news video, I guess, and I just want to make my disclaimer right now that just because I say something is working the way that I believe it works doesn't mean that I agree with it, doesn't mean that I want it to be that way. There's a lot of things in my videos where people get really upset and they think that I like the way that the system works because I'm saying that in a video. Just trying to help people understand how the system works. I'm not trying to say, yeah, this is how it works and it's great, it's wonderful. So this is mostly a bad news video, but sometimes these videos can help people not make very common mistakes that especially self-represented people do. I'm going to save calling the cops and CPS for last just because it's going to get a little thorny. I think I can get through the other topics more smoothly. So, the first thing that I wanted to mention is my opinion is the biggest reason people try to use these methods, whether they want to admit it or not, and whether people giving them advice realize it or not. This is my opinion. Most people are trying to avoid the litigation process, either because it's really expensive, which, if they have an attorney, it obviously is, or because they are afraid of it. They are stressed out by it. It's scary. And if they can get one of these other mechanisms to come into to come onto their side, it just feels, I think, for a lot of people safer and easier. Especially if they don't have to do anything except file a report or pick up a phone. That's very, very easy compared to doing all of the legal research needed to prepare a motion and file it, and then go to court and possibly lose. Or if you have an attorney, pay thousands and thousands of dollars. So please, before you do one of these things, really think about, is it just that you are afraid of going to court because you feel that the judge doesn't like you? Because if you do feel that way, or because you are afraid you can't afford or it's too expensive to use your attorney, then you're probably doing the wrong thing. You're probably using the mechanism that you're thinking about using for the wrong reason. And it's really hard to accept that, but I strongly feel, after having run this channel for all these years and after having represented myself for 8 years, that the biggest reason people use these other techniques or these other mechanisms is because they are not wanting to spend the money with their attorney, or they are, for just some general reason, terrified of the litigation process, which most people are. But that's just something that I want to mention, is that's not a good sign if that's one of the biggest reasons as to why you're doing what you're doing. State bar complaints are free, but they're bound by the rules of professional conduct. If you're trying to complain about your ex's lawyer just because you don't like what they're doing, that's not going to go anywhere. They're going to look through the rules of professional conduct to see if there's a violation. Oh, and just because you allege there's a violation doesn't mean you're going to be able to prove it. One of the most common things people will complain about with their ex's lawyer is they lied. How are you going to prove that they lied? Because lying is a knowing thing. Somebody could say something that's not true that they didn't know wasn't true. That's not a lie, they didn't know. How are you going? That's the hardest thing is people will say, "Oh, well, I have tons of proof that my ex's attorney lied," but they don't know that they lied when they did, or they certainly won't admit it. A lot of people think that attorneys should fact check their own clients. Guess what? The legal system doesn't think that. So you can think that all you want. The legal system doesn't think that. The legal system thinks that they have a client that they're supposed to advocate for. If they make certain outlandish claims that look bad, like for example, outlandish claims against a judge, that's different. But if they just are representing their client and they're trying to win at all costs, most of the legal system is going to think they're doing their job. And I talk about that in the video, win at all costs. Typically, filing a state bar complaint or grievance against your ex's or opponent's lawyer is going to go nowhere fast because they're going to look at your complaint and they're going to see that you're complaining about your opponent's lawyer, and it's going to be taken with the tiniest grain of salt possible. Complaining against your own lawyer, that's different. There's all kinds of other things that come into play there that don't just have to do with, oh, they lied. There's contracts that they may have not followed. There's certain duties that they may have not complied with on representing you. That's different. So that has a chance of actually going somewhere. If you're going to complain about your own attorney, then this video doesn't really apply to you. This is mainly for people, especially in a high conflict child custody case, who want to file a bar complaint against their ex's attorney. So, I mean, it's like I said, it can work. It's going to be taken with the tiniest grain of salt, and it most likely will be used against you if it doesn't work. Just so you know, when you go back to court, most likely that attorney is going to say, hey, this person's case is so weak that they don't even have a case against my client. They're having to bring up cases against me. If people don't think that that is going to affect the opinion of the judge, then I feel really bad for you, because it will. And that's why they'll bring it up. So before you do that, just keep in mind, filing a bar complaint against your ex or your opponent's attorney is likely to blow up in your face, with extraordinarily rare exceptions. And if it's going to be an exception, it's hopefully not they lied. It's just hopefully something else. Maybe they, I don't know, cussed you out in an email or something that doesn't have to do with they went into court and lied, because they've heard it a million times and they don't care. If you want to learn why they don't care, watch my video on the topic, win at all costs. People expect the attorney to do everything in their power to win their case, and to them, being creative about the law and the facts is not, I guess, what do they call it? Suborning perjury. I don't know, guys. I know that there's going to be people who are really upset about this, but the reason that I'm saying this is because it has a very low chance of success, and it has a very high chance of blowing up in your face. And there's a lot of other channels out there who are like, yeah, look, I did it and it worked. Here's this video on YouTube about what you could do against your opponent's lawyer. And it gives people this sort of sense of, it inspires them to try it. And those videos don't explain what could happen to you if it doesn't work. That's what they leave out. They talk about, oh, look, it worked. This is a great thing you could do if your opponent's lawyer is a liar. And that's great that it worked in that case, but that's like winning the lottery. And as I said, guys, it does not talk about what's going to happen to you if it doesn't work. So next we have Commission on Judicial Discipline. You can file complaints against judges, also free. Also, takes very little effort. You fill out like a little application and turn it in. There's no legal research or anything like that. It's just like with the bar complaint. But just like with the bar process, the grievance process, just because you don't like what the judge is doing doesn't mean you're going to get anything done from the commission. They are also bound by a system of rules, and those rules are called the judicial canons. So if there's not a violation of a judicial canon, they can't help you. If the judge made a mistake in your case, they're going to send you to the Supreme Court. That's their job. The Commission on Judicial Discipline's job is to see if there's a violation of the judicial canons. A lot of people think, well, there's all these laws they're not following. Okay, that's outside of the boundaries of what they're there for. The Supreme Court's there for that. If there are laws that are not being followed, there are appeals and writ petitions. The Supreme Court steps in and fixes that problem. I guess there is some kind of notion of not following the law on purpose, but no judge is going to admit that. If you complain about a judge and say they didn't follow the law, they're probably going to say that they think they are following the law, and if they're not, then they made a good faith mistake. They just didn't know. Which, that's allowed. That's going to shock people. People are going to be really upset about that, but that's exactly what the legal system thinks. If they are going into the Commission on Judicial Discipline and they tell the commission, this is exactly how the law works, and I didn't follow it on purpose because I don't like this person, then yeah, of course you're going to win. Of course you're going to get some kind of imposition of discipline on that judge. But who's going to go in and say that? No judge is going to go in and say that. That's just ludicrous. You're going to get exactly what I said, which was there were certain laws that they were applying. They thought they were applying them correctly, and to the best of their ability, they are. If they were overturned on appeal, then they'll say, okay, well, I realize now I'm wrong. I'm sorry. I made a mistake. That's where those cases go. And that's the same thing with these people who sue the judge in federal court. If they're doing their job and they make a mistake, the federal court's going to say, file an appeal. They're not there for that. There are certain things that people can go after, like police and judges for, but they have to be acting outside of the boundaries of their job. They have to be going and abusing their power in certain ways. If they're just sitting on your case and doing their job as a judge and they making mistakes on the law, that's still them doing their job as a judge making mistakes on the law. They have immunity. That's I covered that in a different video called Judicial Immunity. But if there's a judge who's like taking like phone calls from some guy that's your enemy, and this guy's like, yeah, I hate this person, make them lose their custody case, we'll use this example, and that's why they rule against you, okay, fine, there's a federal lawsuit, but you can't just allege that, you have to prove it. So it has to be something that has not, the judge is ruling against you for reasons that have nothing to do with your case, like what I just described. These things are outlandish and extraordinarily rare. Most of the time, people are mad that they're losing their case, and they think that automatically there's some kind of secret, insidious reason as to why. And I've talked about on this channel that, in my opinion, most of the time, it's just incompetence. That's not a suable offense. If you want to learn more about what I mean, please watch my video on the topic, high conflict incompetence. I talk about it. Judges are trying to do their job correctly, and they're just screwing up. They just don't know what they're doing. Details are in that video because it's more complicated than it's not that they're stupid. They just don't understand high conflict child custody, and so they're making mistakes because they don't understand it. In any event, guys, incompetence is not a basis for Commission on Judicial Discipline complaint, and nor is, well, there is a few examples, but it wasn't rulings themselves. It was not making rulings. So yeah, the commission will deal with incompetence when a judge just isn't making any rulings at all, like no rulings. And that was, there was an example here in Washoe County. His name was David Humke, Judge David Humke, I believe. And he was disciplined for incompetence. It wasn't that he was making the incorrect decision, though he probably was. The guy just wasn't making any rulings, and that was a huge issue. So I want to mention a couple of things. Bar complaints. How many have I filed? None. Commission on Judicial Discipline complaints. I did file one, and it was not against my family court judges, believe it or not. In fact, I won 4 Supreme Court / Court of Appeals appeals, and not a single one. Well, I only mentioned one. My one judicial discipline complaint was not filed against any of those judges. As frustrated as I was with my family court judges and also with Judge Scott Freeman, I did not feel that they did something that violated the judicial canons. I just thought they were wrong. They made a mistake. I feel like they applied the law incorrectly because they didn't know what they were doing. That's not a basis for a discipline complaint. The one that I did file was against a summary eviction judge, and that one went pretty far, but it didn't go all the way to discipline. So I just wanted to let people know that, as an example, I was representing myself in a high conflict child custody case for 8 years against 2 different family court judges, and I didn't file a Commission on Judicial Discipline complaint against either of them. So if there was a way to kind of give you guys an example that I'm sort of practicing what I preach, that's, I hope, a good enough example to you guys that I solved those problems with the Supreme Court, which was what the Supreme Court was there for, and the Court of Appeals. Same thing with, I think I mentioned this with judicial discipline complaints are free also. Police reports free, CPS free. I'm going to save those for the end, though, before I talk about it. But yeah, I mean, it's not, I very much notice and re-emphasize what I said in the beginning, is that these mechanisms are free and very easy to use. And I think that that's one of the seductive things about those using those approaches, rather than spending hours and hours putting together a motion, filing it, and then getting chewed out in court or having to go up against a scary attorney. You just don't want to spend the time, you don't want to spend the money, so you're going to use these other mechanisms. And then of course, if they do go somewhere, it triggers other people having to do the work for you. So the state bar is going to have um, Office of Bar Counsel doing all the litigating for you. The Commission on Judicial Discipline is going to have a prosecuting officer who does all the litigating for you. I guess the exception would be if you sue sue a judge in federal court. That's different. But most of the time, I think what people are looking for is an easy, quick, cheap way to solve this problem, and the problem that they believe that they have. And I know it sounds bad, but I have to talk about it on this video because it is my opinion that this is what mostly is fueling people into taking these approaches. And the reason I do this is a little bit of tough love, is that the other channels and that the people who are giving you advice to do these things are not talking to you about the way that they can backfire. That's the thing that really gets left out. There's a lot of people that will give the advice to do this stuff because they mean well, or because they just want to get rid of you. They just don't want to talk to you about it anymore. They're just trying to get rid of you, and they're like, file a police report, go file a CPS report, go away. And they're not talking to you about how this stuff can backfire. And if you go into court and you say, hey, I didn't know this was going to backfire, these other people told me to do this, judge isn't going to care. Trying to change the judge. This is one of the most common approaches that people have, especially in child custody cases. They feel like, this is how I'm going to solve all my problems. I'm just going to get a new judge and everything is going to get better. And so there's a lot of people, parents, that obsess about this, and they file motion to disqualify, motion to disqualify, motion to disqualify. And they feel like that's their whole case. There's all of these actual things that they need to resolve in their case, but in their head, their entire case is changing the judge. And they just go crazy trying to change the judge, thinking it's going to solve all their problems. And each time the motion is denied, they look crazier and crazier. If you are trying to disqualify a judge, it has to be for bias. The biggest thing about bias is that it is some kind of judgment against you that doesn't have to do with the facts of the case. If you start to go to hearings, or you start to file paperwork and you start to get rulings entered against you, you're already at a huge disadvantage for trying to allege bias, because now the system, the judge, and your opponent are going to say that you just lost, that you're just a sore loser, and that since you lost, now all of a sudden there's bias. If you want your allegations of bias to be taken seriously, they have to be done before the judge starts entering rulings. And that sounds completely backwards to people, but really, they're the ones that are thinking completely backwards. You have to do your research on the judge before they start entering rulings. And the safest way to get rid of them is the peremptory challenge of judge. If you can do that, some states don't have it. Watch my video on the topic peremptory challenge of judge. It always works. It costs money, but it always works. And of course, you have to do it according to the rules. So it has to be done before the judge enters any rulings, and you only have a certain amount of times that you can do that. But it always works. It's a wonderful mechanism. If you don't have that available to you, you can try the motion to disqualify, but your best bet is to do it immediately and to explain why are the reasons, what are the things that are in place that are indicators of implied bias or actual bias. If you wait until the actual hearings start and the litigation starts and you start losing your case, then the other side can say you're losing your case because of the actual things that are in front of me in the case, which is not bias. When they are considering evidence that has been put forth and they're making a decision against you based on the evidence that's been put forth, that's just them doing their job. That's not bias. But it's just, there's so many people who think that, oh, I lost my case, they must be biased. And it's an absolutely crazy way to think of how bias works, but that's what they do. And it looks so bad. It looks bad on any attorney or litigant who waits until after they lose their case to complain about bias. It's so bad. And that's because so many people do it. Lawyers, not so much. Lawyers are much more cautious about using the motion to disqualify. But judges, self-represented people do it quite often. And it's going to just make the judge lump you in to all of the other, what they perceive to be crazy pro se litigants. That's exactly what it's going to do. It can backfire and it will backfire. The other thing that I wanted to mention was suing the judge or filing judicial commission complaints against the judge to trigger some kind of bias recusal. There's case law on that doesn't work, but there's some people who think it does. And so they will go and sue their judge in federal court, or they will file complaints to the Commission on Judicial Discipline. And then they will go back to their judge and they'll say, hey, you're biased now because I filed these reports against you or because I sued you. And there's case law that says that actually is not how it works, because if that was how it works, then yeah, you could just change a judge anytime you feel like it by just suing them. And so obviously that's not going to just automatically become a basis to recuse. And in some situations, they don't even know about it. So like if you file a Commission on Judicial Discipline complaint against a judge, there's like 3 different phases that they go through. And the first phase, it's confidential. They don't even tell the judge. So that's probably to avoid this kind of nonsense. So yeah, I did want to talk about that. It will be used against you if you file a bunch of these disqualification motions, because your opponent's attorney is going to say that you're just a sore loser. You're a sore loser and you're filing these motions to harass and annoy everyone because you think that your terrible case, which isn't going anywhere, has no chance of going anywhere unless you get some kind of new judge that you can dupe or trick. That's the way that they're going to characterize it. Whether it's true or not doesn't matter. That's the way they're going to characterize your attempts to change the judge. In the past, I would have said that changing a judge has almost no chance. Well, I'm going to still say that. I think that in the past, I felt that it was impossible to change the outcome of your case by changing the judge. And I think in an ideal world, that's the way that it's supposed to be. But now I have more experience, and I will just say that there are some situations, especially those where the judge has very wide latitude, a lot of discretion, so family court. There are some situations in those areas of the law where the judge's opinion goes way further than it should, where changing the judge can actually change the outcome of the case. But they're still rare. I mean, I can only think of 2 judges right now off the top of my head, and I think it's just because they're really old and they're stuck in their ways, and they just do not believe in the law as written, and so they violate it on purpose. So in those particular situations, I think that if the judge was changed, then you would see a different outcome in a case. But for the most part, with most of the judges, I don't think that would happen. A lot of people, there's a case I can think about right now, 2 cases actually, where these 2 family court litigants spent years trying to change their judge. Years. And they finally changed their judge, and now they're trying to change their new judge. So their new judge ruled against them. They don't like their new judge, and they're trying to change their new judge. And so it's just this obsession, that never-ending obsession that this particular judge isn't following the law, so I need a different one. And to just keep on shopping for judges until they finally get what they want. In their mind, that's what they're thinking is going to happen. Okay, so I've talked about, let's see, the bar grievances. I haven't talked about the fee dispute. So you can't really use a fee dispute against your ex's lawyer anyway, at least not that I know of. You can do it to your own lawyer, and as I mentioned with bar grievances, if you're filing it against your own lawyer, you're probably fine. I mean, that's what that stuff is meant for. That's not really considered an attack on a collateral attack. But I did want to talk about it a little bit, which is that if you have issues with what your attorney is doing with respect to billing you, you think they're charging you too much or they shouldn't charge you for a particular thing, then yeah, you can file a fee dispute. I think all the states have this. And it's just an easy, streamlined way for you to try and get some money back based on your dispute with what you've been charged. Really quickly, I think I did talk about accusing. I'll talk about this a little bit more because this is a big thing. People talk about their ex's attorney or their opponent's attorney lying about the law and the facts. If they go in front of the bar and they tell them, yeah, this is how the law works, and I purposefully argued to trick the judge into violating the law, of course they're going to get disciplined. But that's not going to happen. It's not. And I can't think of any way of proving that. Um, and when I, what sucks is when I say these things, I can already imagine people saying, well, I can prove it. I can prove it. And so then they'll want to go ahead and try and do this. And they just don't know how the system itself feels about this. And in my opinion, unless they leave like a voicemail on your phone saying, yeah, this is how the law works, haha, I tricked the judge, it's not going to go anywhere. It's just not. Their job is to win the case for their client, and they are going to take what their client says at face value with very rare exceptions. It's not their job to be the judge before the judge, even though that's what a lot of people wish. It's not their job to do that. And it's not their job to call their own client out. And if they do call their own client out, which is going to be rare, it's not going to be in front of anyone. It's not going to be in front of the judge. It's not going to be in front of you. They're going to do that, privately with their client. If they, when some of the family lawyers are different and they won't do things that they think will harm a child. But those are not the types of lawyer that your ex is going to hire. If you're in a high conflict child custody case and your ex is an abuser, they're going to shop for lawyers until they find an unscrupulous one. They just are. And so the real problem, where the blame lies, really is with the judge, not with your ex's lawyer. So if you think that you're going to focus intensely on your ex's lawyer to find some way to cripple the lawyer or get the lawyer kicked off the case or something like that, it's another rabbit hole that is going to become an obsession that isn't going to go anywhere, and it's going to backfire and get used against you. So if you're trying to find who to blame, I have a video on the topic, who's to blame. I think I call it you know what, I know the word blame is in the title, you're going to have to search it, but I do explain that most of it is on the judge. If there's a lawyer who's doing things they shouldn't be doing, if they're not checking on their client, if they're just believing the nonsense that their client is saying, it's really the job of the judge to say, yeah, you're wrong, and this person over here is right, and they win. I mean, really, that's where you have to focus your attention on the judge. The judge is the one making the decision. Yeah, your ex has support from a lawyer and maybe other people, witnesses and such, but it's the job of the judge to make the right call. And so trying to keep focused on the facts of the case, on the law, and on briefing the judge and on getting the judge to make the right decision, that's really where most of the focus has to be, not on trying to alienate their witnesses, target their witnesses, threaten their witnesses, threaten the GAL, sue the GAL. This is the stuff that a lot of people do that just backfires. I didn't talk about that, but I guess I could. It's a video on collateral attacks. Suing the GAL counts. People do that too. There's videos out there where I guess it's worked before. There's also a great video, somebody I guess secretly recorded a GAL meeting. Okay, these are probably very true things. These are things that are alarming. It's true. They shouldn't be happening. But how are you going to make it work in your case without it backfiring? That's the thing those other videos leave out. There are people who have successfully gone after a GAL and they don't mention what's going to happen to you if it doesn't work in your case. And that is what really upsets me, is because people will say, look, Alex, you're wrong. It sometimes, okay, well, that's great. But what about your case? How is it going to work in your case without blowing up in your face? That's the really scary thing for me. That's why I do videos like this. Yes, it's possible to go after your ex's attorney and win, or to sue the judge and win, or to sue the GAL and win. It's possible, but very, very, very unlikely to work, especially if they claim that they thought they were doing the right thing and they accidentally made a mistake. Because if that's what their claim is, they're going to get immunity. Incompetence, as far as I know, it's not going to get you around the immunity thing. That the way to get around immunity is the same example that I gave with the judge. So I mean, if maybe the GAL takes some bribe money, maybe somebody bribes them, like, here's 50 grand, rule in my favor because of the money I just gave you. If you can prove something like that, then obviously that's a lawsuit, because that's not the GAL saying, hey, I was trying to make the right call for this child and I just accidentally screwed up. That's obviously the GAL making a decision in your case based on something that has nothing to do with your case. A bribe is an external thing. Okay? Maybe they just, for some reason, got, like, they needed money. So yeah, they needed to take some money from somebody to do a certain thing. I mean, okay, if you can prove it, that's great. But most of the time, that's not what people are saying. Most of the time, people are saying that the GAL didn't meet them enough, or that they didn't have, like, the knowledge they needed on narcissism or something like that. And these are accusations of incompetence. If they're not meeting you enough, they're not doing their job the way they should be. If there's a lawsuit that says if there's some kind of case that says that you can sue them for acting within their role, just not doing a good job, that's news to me. Mention that. But most of the time, the way to deal with that is the actual court case itself. If you go into court and there's a GAL report and it's damaging, you can tell the judge, this is not good because they didn't, follow these particular doctrines of abuse and neglect, or they don't know about domestic violence, or they only saw me 2 times. Those are valid things you can do. That's not suing them. That's not trying to take their license. That's you just doing your job in your court case, saying that their report shouldn't be listened to. Or if they're on the stand and you cross-examine them, you can do those things. That's allowed. That's perfectly fine. That's not going to backfire. But trying to attack them, trying to attack their license or sue them in federal court, that's the stuff that this video is warning you about. So yeah, if you have a problem with the GAL report, or any other witness, really, any other witness, teacher, doctor, same thing, trying to get the teacher fired. People have tried to do that. Trying to sue the doctor in front of their medical board. People have tried to do that. It comes off so poorly, because they're just going to say, yeah, this person who sued me is a sore loser. I went and testified in their custody case and they lost their kids. And so now they're trying to take my license. It makes you look really bad. And then it can also come up in the case, can get brought up in the case. So if you're cross-examining them on the stand, nobody's in it. That's fine. That's what you're supposed to do. If you're cross-examining them on the stand, if you're going through discovery, if you're having them explain to the judge how they did a 10-page report when they only saw you 1 or 2 times, that's the way to go about doing that. That's the correct way to deal with that problem. That's the way that the system expects you to deal with that problem. It's not expecting you to do all those other things that I mentioned. So let's see here. Legal malpractice lawsuits, I didn't talk about those. Those are okay. So first off, I don't even think it's possible to do a legal malpractice lawsuit against your opponent's attorney. So that's already a good sign. A legal malpractice lawsuit against your own attorney, it's the same sort of opinion that I have with regards to filing a grievance or a fee dispute against your own attorney. You're probably going to be fine, because you're not trying to deprive your ex of representation. You have a legitimate beef with your own attorney. Legal malpractice is different in that you get to actually litigate the case, so you get to turn the wheels of justice, but it does come with all sorts of other risks. I think I have a video on the topic. I think it's called Attorney Malpractice. Maybe it's Legal Malpractice. Check both titles, see if you can find it. You can learn more about it with that video. Disqualification of counsel. I should talk about this a tiny bit. A very tiny bit, because I have a video on this topic. In fact, watch the video on the topic, disqualification of judge. Watch the video on the topic, disqualification of counsel. Tons of details in those videos. I will mention very briefly right now that is not a good idea if you think that that's going to be the way to solve your problems. You're losing in court, and the only thing you can think of is to disqualify your ex's lawyer. There are legitimate ways to do that. You should research it very, very, very carefully. A lot of people do not know what conflict of interest means in the context of disqualification of counsel. They don't know what that means. And so you should watch that video and learn about it, because if you try and do that and you fail, that will blow up in your face, because the other lawyer is going to say, hey, this person's case is so weak that They don't have a case. The best thing they can do is try to take away my client's lawyers so that they are defenseless in court, and they can just bully them. So you're trying to take away their champion. That's the way that they're going to portray that. And if you have a legitimate basis for disqualification, it's usually something along the lines of, I went to that lawyer and I sat in their office and we talked about my case. And now, because I didn't hire them, my ex hired them. And that's really messed up because they know all these secrets about me since I talked to them as an attorney client, with an attorney client relationship. Okay, that's actually a basis to disqualify. But then there's people who will come up with all kinds of other reasons that they think are disqualification bases or that they think is a conflict of interest. And it sounds, I guess, plausible to somebody who doesn't know anything about the law, but to the judge, they sound like a crazy person because they've read all the case law on it, and it's really a narrow thing. It's not something that you can easily do. Taking away somebody's attorney is a very difficult thing for good reason. I mean, one of the basic principles in this country is that a person has a right to choose their lawyer, and you shouldn't be able to take away their lawyer. Again, guys, there's a video called disqualification of counsel, and that goes through how that works if you want to watch that video. Let's see. Sanctioning an attorney. This is a little bit more possible than a lot of the other stuff that I talk about in this video. Yeah, there are rules and I think statutes that allow you to get the attorney sanctioned. It's not as bad if you're doing it within the same case. If you're filing a separate lawsuit or a bar complaint or something like that, that's the stuff I've been talking about. But if you are filing some kind of motion in your own case with the same judge, that's considered a little bit more reasonable because you're not trying to shop for another judge or anything. It usually doesn't work anyway. But my opinion is that if a judge wants to sanction a lawyer, they're going to sanction the lawyer on their own without you asking them to. Or there are some situations where you really can't tell whose fault it is. Those are actually okay also. So say somebody isn't complying with the discovery order and you want to sanction them, but you really don't know whose fault it is. Is it the client who isn't like turning documents over to their lawyer, or is it the lawyer who's lazy or they're not doing their job? In that situation, it's totally legit to say, hey, Your Honor, somebody needs to be sanctioned here. I don't know which person should be sanctioned because I don't know whose fault it is, but I was supposed to get this discovery by this day and they didn't turn it over to me, and I had to file a motion to compel. So please, let's get to the bottom of whose fault it is and sanction whoever it is. If it's the lawyer, sanction the lawyer. If it's the client, sanction the client. That's completely above board, and that's something that happens. It's normal. But if you're just gonna out of the blue, a motion was filed and you think it's full of lies, and you're just gonna out of the blue file a motion to sanction the lawyer for lying, that doesn't look good. So you really have to know what you're doing when it comes to sanctioning the attorney. And it seems to me that when the sanction is just legitimately warranted and you don't know who it should be applied to, that's the time when it's safe to do that. If you're just mad at your ex's lawyer and you can't get rid of them and you're trying to just harass them and you file a motion to have them sanctioned because you don't like that the document is full of a bunch of lies, I mean, that's something that's just considered normal for court. I know people aren't going to want to hear that, but they weigh the credibility of the witnesses. That's just what they do. If there's two witnesses, they weigh the credibility and they decide who's right and they decide who's wrong. They don't just automatically assume that the person who's wrong lied. And that's because it gets complicated. People don't like to hear that either. But there are people who claim things and they think they're true when they're not. And for a judge to try and get to the bottom of it, it really goes into perjury, which is a criminal thing, they can sanction if they want to. They're just so busy, guys. They're so busy and they don't want to do it. And if you push too much, it opens you up for the claim by your opponent that you're not even focusing on your case. I mean, you're stuck on all these little details and you should be focusing on the meat of your case. And since you're not doing that, they try to insinuate that you have a weak case. So I guess I was going to talk a little bit about forcing your attorney to do things. There are some people who will do their own research on statutes, rules, and case law, and they will tell their attorney that they should be putting these cases in the documents or that they should be filing a very specific type of motion. Most of the attorneys do not like that, and they'll get ticked off. Some of them are okay with it though. So if you try, I mean, if you bring something up to your attorney, hey, I'm wondering about this case, or I'm wondering about this filing, and they're open to discussing it with you, then that's good. Have a discussion with them. Some, especially the newer attorneys, they're doing that more with their client. They're working as a team. Other attorneys do not like it and they will get annoyed. They will either ignore you, they will shut you down, and if you keep pushing, they'll withdraw from your case, or they'll just continue to ignore you until you want to fire them. And it sours their relationship. It makes it worse and worse. A lot of the attorneys will have this opinion that if they don't want to bring it up, it's because they don't feel like it's something that's professional. And so they'll feel like you're asking them to do something that's a violation of the rules of professional conduct, that it's not consistent with the law, and they don't want to get in trouble for it. They may explain that to you, or they may not explain that to you. If you're paying that attorney, they're probably going to be like, just hire somebody else. I'm done with you. It honestly, you can try to get your attorney to file something or to include a certain case in a brief. But if they're not going to do it, then really you either need to get a new attorney or you need to represent yourself, because, or you could just suck it up and just go with your attorney and just give up. I mean, really, there's only three roads here: represent yourself, get a new attorney, or just drop it. But some people won't, and they'll just keep sending messages to their lawyer and calling them, and they won't choose the other two roads. They'll just stay with their lawyer and keep bugging them. It's not a good idea. It's going to annoy your attorney, and they're going to get to the point where they just don't care if you lose. And you don't want an attorney who's not caring if you lose. You really don't. So really, guys, I'm sorry to tell you that if you're trying to get your attorney to do something and they won't do it, you're going to either have to drop it, get a new attorney, or go it alone. That's it. It's a simple solution that is terrifying to people. They don't want to represent themselves. They don't have the money to hire a new attorney. They've already put everything into their current attorney, and they're terrified that they're going to go to jail or lose their kids or something because their attorney isn't doing what they're saying they need to do, and now they're going to lose because of that. I get where the fear is coming from, but there isn't really much you can do with it. You're just going to have a ton of fear because that's just the way it is. It sucks. I'm sorry, guys, but it's a common thing that I get messages on. Okay, calling the cops. 8 years I represented myself. I proved abuse. I proved neglect. Guess how many times I called the cops? 0. I just knew it wouldn't go anywhere. I knew it wouldn't go anywhere, and I felt like it was going to backfire on me if I tried. And I get why so many people give this advice. Oh, if your ex is abusing the kids, call the cops. I get why they do that. And I think that they mean well, but it can backfire, and it does backfire on people. My ex actually called the cops on me once, and it backfired on her. In fact, you can watch the video where it backfires spectacularly. It's in the My Docket series. You can watch the hearing video, and the judge blows up on her for calling the cops. So yeah, it was used against her in court. My Docket series, see for yourself. Usually the cops, even if they come, won't do anything usually. Sometimes they'll try to intimidate or trick your ex into. I'm assuming that you want the kids. Let's just assume that's what it is. That's usually what it is. They're not turning the kids over. They're violating the court order. 911, please save me. Okay, so sometimes the cops will go and they'll intimidate them or trick them. They'll open the door and they'll say things like, you could go to jail, you never know, this might be a crime, this maybe might wishy-washy, who knows. And then your ex gets scared and turns the kids over. And people will say, yes, it does work. And then there's YouTube videos, oh yeah, I used the cops and it worked. And so then people think, look, it worked for this person, let's do this. That's just because they were intimidated. The cops don't actually have the ability to snatch the child unless there's a pickup order. We'll talk about that in a second. They don't have the ability to do that. It's a civil issue. It really is. There's something called contempt of court. If the court order is being violated, you go back on contempt. The reason people don't want to do it is because it often fails. They spend all this time and money. They get stressed out. Sometimes they get sanctioned. I get it completely. I understand. But there's still consequences to calling the cops, especially if you call them over and over again. So I'm sorry to have to say the truth of what happens in these cases. I'm sorry to have to say it, but it's not something that is as safe as people make it seem. People make it seem like you can call the cops 25 different times. And if they do something great, and if they don't, it's okay. It's not how it works. It will be brought up in court. It will be used against you in court. So if you're going to call the cops, you better hope that it works. If there are like messages where your ex is saying, I think I'm gonna die. I took too much of this drug, or I've been stabbed. Something really scary like that. That's different. The cops will probably use that. They'll probably use that message as a basis to seize the child. But if it's just something like, hey, we have a court order for visitation and they're breaking the order, why are you calling the cops for that? That's the way I feel about it. And it's also one of those things that is definitely, in my opinion, gender biased. So, like when the dad calls the cops, they don't even try that hard to get the child back. They're like, oh, well, the child's with their mom. It's okay. But when the mom calls the cops, uh-oh, this isn't good. And so they'll try and usually go more, they'll go a little bit further and try to intimidate the dad more, or trick the dad, and deceive the dad. Um, Pickup orders are different. I will go ahead and say if you got a pickup order, definitely call the cops. That's the point of the order. The point of a pickup order is it's very specific. It instructs the cops to seize the child and turn the child over. So yeah, that's different. They're not being asked to interpret a schedule like a timeshare. They're going to have a piece of paper that says to such and such, you are hereby ordered to go and take this child from this person and give this child to this other person. Okay, that's use the cops for that. That's the point of it. That's the whole point of a pickup order. Um, the other thing that I will mention, I guess, is in situations like, I guess they have child abduction, kidnapping, that kind of stuff. That's a crime. I'm not sure that the cops really do that, though. That I think that what happens is that gets assigned to a detective, and then a detective is going to call you back, and they're going to work a case, and maybe it'll go to a district attorney. It's not a really quick process. It's not like just the regular old police show up in their cop car with the lights on and get your kid back. It goes through like a process, an investigation process, and it's similar to any other crime that's not just like obviously occurring. And the detective will work with you, and then the DA, if they decide to file charges, they'll work with you. That's a different sort of situation. And I think if you go about that calmly and as calm as you possibly can, you might actually get them to listen to you. I've covered a few of those cases on Our Nevada Judges, and they're definitely interesting cases. The public likes to watch those cases because that's something that they talk about in the news a lot lately. There's a lot of these cases where this is a problem. Um, Calling CPS. I guess this is the last topic. I saved it for last because it's the most convoluted. 6 times people called CPS against my ex. I know the details of 3. I don't know the details of the other 3. None of those 6 times was me. I never called CPS. For all I know, the 3 reports that I don't know about, maybe my ex called CPS on me, possibly. Who knows? Because those 3 I just couldn't get any details on. But CPS didn't ever do anything. They did absolutely nothing in my case. Nothing. 8 years representing myself. I proved abuse, I proved neglect, and I took care of it myself. That's how it works for most people. It just sucks because it takes so much stress, time, and money. CPS is free. You pick up the phone, you call, and then if they decide to do something, they'll do it for you. They'll do all the work for you. The caseworker will do all of the phone calls. And then if it goes to a court hearing, the district attorney will do all the work, file all the papers. It's very little work for the complainant, and all of the work goes to the government. The system itself does everything. I get why it's appealing to people because of all of those reasons. The other thing I was going to say before I move on is that they have a different standard that they go by. It's not as easy as you think to use CPS. A lot of people think it's easy because it's free or because they don't have to put their own work into it. But the legal standard is very different, and that's what makes it tougher. Not only is the standard different, the level of proof that they need is also different. So you can prove it by preponderance of the evidence for the most part and get the relief. They have to prove it by clear and convincing, and they also have to give your ex a free attorney. And they also have to let your ex has to get an opportunity to um, accept services. So it really ties an arm and a leg behind your back. it's not the best approach. People think it is because it's so easy, but they don't realize all of the complexities behind it. I have multiple videos that go into details on why this is the way it is. The first one is abuse and neglect proceedings. The second one is abuse and neglect proceedings revisited. And then there's another video, I think I talk about it. I think it's called exit orders. And so these three videos will disclose or reveal to you how convoluted CPS and the process of CPS is. And it's one thing if you're using CPS, but you're still litigating your own case. It's another thing if you're like, I'm going to just wipe my hands, I'm not going to do anything, and I'm going to put it all in their ballpark. If you're doing that, that's not good. Because, as I mentioned, there's a completely different legal standard. And if you go through my case in my docket series, you'll see this come up, where my ex tries to use CPS as a shield, trying to say that they didn't find anything wrong with her. And I point out, well, that there's a different legal standard here. And the judge agrees with me, and he says, yeah, it doesn't matter that CPS decided not to go after you, because the best interest of the child standard is different from what they're looking for. They're looking for abuse and neglect, and there's specific statutes that articulate what that means. Whereas you just can argue best interest, and you don't need as much proof as they do in the other court, and they don't get a free attorney either. So that's another thing. So guys, really think it through. Watch those videos before you call CPS. And yes, calling CPS can backfire. That's another thing. A lot of people will say, just call CPS. You're telling me, you'll text your friends or your parents or whatever, and they'll be like, wow, I can't believe your kids are being abused so badly. You should call CPS. They mean well, or they're just trying to get rid of you because they're tired of hearing it. They're sick of you, and they're like, okay, just call CPS. Stop bothering me. They either mean well or they're trying to get rid of you, and they do not realize that it can backfire. And there's the same thing with all the other videos out there that are like, oh yeah, CPS does work. Look what happened in my case. And none of those people are talking about what can happen to you if you're wrong, and how if you do it a bunch of times, it's going to get used against you in the sense that your case sucks so bad that you aren't even trying anymore, and that all you do now is call CPS because you're lazy and you don't want to do it anymore. You're just going to try to find all these other people to do all your work for you. The other thing they're going to try and say is that, hey, you did call CPS on my client 2 times, and both times it was unfounded. And so since it was unfounded, then yeah, you can't bring it up again in this case, which is wrong. That's not how issue preclusion works, but they'll try and say it anyway. And they'll try and insinuate to the judge that somebody else already looked into this judge to try to kind of get the judge on the road of finding some reason to deny you. They're not supposed to do that, but they will do that. The family court lawyers will do that. Like I said, guys, there are legal principles under res judicata, specifically issue preclusion, that explain when you are precluded from bringing an issue to your judge. And CPS having decided that something is unfounded is not one of them. But it doesn't matter. They will still bring it up to try and say that this has already been looked at. So let's just find some reason to just say that this is nonsense and get rid of this particular complaint or motion. So yeah, it can be used against you, and it will. That's just, you guys, these are things that are there to help the public. And I understand that. And I'm not trying to say that you shouldn't do it because it's my personal opinion. Like it's like some kind of ideology that I have in me. I'm trying to say that you shouldn't do it because I have seen what happens in the courtroom in my own case, and as I observe other people's cases, where nobody talks about this when they say use CPS and call the police. But what happens is all of a sudden you're the bad guy for doing that. All of a sudden you have a weak case because you did that. And that's what isn't talked about enough, is the backfiring, the way it can blow up in your face. It's not talked about, and then it happens, and then you're like, well, all I did was what people were telling me to do, and now I'm in an even worse position than I would have been if I just didn't even do that. So I hope that makes sense to you guys. I hope that this video isn't as upsetting to as many people as I think it will be, because this is one of the things that happens in these types of cases is you start to get stressed out, you start to ask everybody for help, and then everybody starts telling you to call CPS and call the police, which then leads to you actually doing that, which then leads to your opponent's attorney bringing it up in court to make you look like the bad guy. That's the reality of what happens. So I hope this video, guys, by the way, this video all by itself is not really a great compass for how to deal with your case. This video is just one piece of a very large puzzle. So if you're here for the first time and this is your first video, please watch all of the other videos on the channel, because to get the full picture of what to do in these cases, that's really what you have to do. If you just watch this one video, it's going to be really frustrating. It's going to be like, okay, well, Alex is telling me there's nothing I can do, so I should just give up. That's not what I'm saying. There's a bunch of other videos out there that give you different approaches. And then there's the My Docket series, which shows you my 8-year-long high conflict child custody litigation, which is full of all sorts of examples. So yeah, this is just one video, a little bit of a depressing video, I'm sure, for a lot of people, but it's not the end all be all. It's just one piece of a larger puzzle. Please watch the other videos on the channel. If you have any questions or comments, definitely post them down in the comments below, especially if it's blown up in your face. If you have done any of the things mentioned in this video, because that's the advice that you got, and then it blew up in your face, please post it down in the comments, because that's the stuff that people don't talk about. And I think it would help a lot of my viewers to see, hey, Alex isn't just saying this. Here's another 20 or 30 comments of other people who called CPS or the police because that's what their friends told them to do, or the lawyers, or the judge even. Sometimes the judge will say it. And then they did that, and then it blew up in their face, and now their case is even worse than it was before. Because that's what people need to see, so they can understand that this stuff isn't, there's no real silver bullet. There's no real golden ticket to victory. This stuff has to all be carefully thought through, including CPS reports and police reports. All right, guys. Again, post your questions, comments down in the comments below, and I will see you guys next time.